Hello. So in this particular session, we are going to discuss this particular news that Supreme Court has upheld the OBC quota in NEET. And in this entire discussion, we will discuss what was the argument that has been put forward by the Supreme Court, especially in the context of constitutions, basically in the context of social and economic basis. And Supreme Court has also discussed this merit versus quota or merit versus reservation, whether merit is the right criteria and for the selection in this particular exams, or reservation is also good to maintain the equality. All these things we are going to discuss, so please keep watching till the end. This is Legacy Academy. I am Pavan Sir. So first we need to understand why actually it is in the news. So it is basically in the news because Supreme Court had upheld the constitutional validity of the quota for other backward class for this particular exam, that is NEET, and Supreme Court says that reservation is not at the odds with the merit. That means reservation is not going against the merit. Even with the help of reservation only, we are going to promote the equality. That is what expected by the policy makers from the constitution. So all these things we are going to discuss here is, first thing is first, what is the constitutional argument given by the Supreme Court. So for example, if we see what are the article numbers are there which are associated with the reservation, so your article number 15 will come, article number 16 will come, article number 335 will come, but here we are going to discuss basically article number 15. So in article number 15, if we see, it is said that state, the definition of the state already has been given under article 12 of our Indian Constitution. So here it says that state shall not discriminate against any citizens. Again, it is the citizen. That means this article number 15, it is available to the Indian citizens only. There are few articles are there which are available only to the Indian citizens. It is article number 15, article number 16, 19, 29 and 30. These are the article 5 are there which are available only to the Indian citizens. So here also it is mentioned, state shall not discriminate against any citizen on the grounds. Again, another important term is only religion, race, caste, sex or place of birth or any of them. That means parameters have been given RRCSP. These are the grounds are there on which grounds the state cannot discriminate. But here term is only. That means if these 5 grounds are not there, if any 6th ground is created by the state, then definitely state can discriminate on that 6th ground. This one thing we need to understand. Another important we need to understand is Supreme Court already observed that if one of the ground has been taken by the state and one more ground, that is extra ground, has been added, then definitely state can discriminate. For example, if we take caste plus education, if 2 criteria we take, then discrimination is possible based on caste even, because here we are not taking caste alone, we are taking education also, because caste will going to provide social backwardness, education is going to provide educational backwardness. So that is this 15 ka 4 we will cover ki state can make a special provision for the advancement of any socially and educationally backward class of the citizens. That means only these grounds are there, on that state cannot discriminate. But if a state is bringing any other ground than a state other than this 5, then state definitely can discriminate. Or if 1 or 2 or 3 different grounds they have been grouped together, then in that basis also state can discriminate. One more article will be there, article number 15(5), that is reservation for the economic weaker section. That is also there. So here what at least argument given by the Supreme Court is, argument is this here, ki article 15(4) basically says that enable the state to make reservation for SC and ST, because reservation for socially and educationally backward classes also and other backward classes also. And article 15 is there that empower it to make reservation in educational institutions. So here we need to understand is, it says that the article 15(1) says that state shall not discriminate against any citizens on the ground of only this. That is already we have discussed. So it is Supreme Court says that this article 15(4) and article 15(5), they are not an exception to the article number 15(1). This article 15(4) and 15(5), they are not exception to the article number 15(1), because article number 15(1) itself actually sets out the principles of substantive equality. What Supreme Court says that this article number 15(1) itself asks to promote substantive equality. And article number 15.4 and 15.5 actually fulfill that substantive equality. Now you will ask, what does it mean by substantive equality? So we are having basically two types of equality. One we can call as formal equality, another we can call as substantive equality. So formal equality basically means it is a belief that for fairness people must be consistently or equally treated all the time. That means if one student A, he actually taking education from the convent school or any English medium school or private schools, and B actually he is taking from that remote areas, he belongs to the remote areas, good education is not available, and this student A also belongs to the 5th standard, student B also belongs to the 5th standard, but A has already taken very good education because he was in the metro city, he was getting good education, but B, because he was living in the remote area, he was not able to access good education. So even though A and B both belong to the 5th standard, but can we say that both are in the same merit? But according to the formal equality, both should be judged on the basis of same parameters. But it will be unfair to the B because B has not received this good education because he was not having access because of his living conditions. That is formal equality. Now comes to substantive equality. Substantive equality, it goes beyond this basics of recognizing the equality of everyone and identifies differences among the groups of peoples with the long-term goal of greater understanding. That means substantive equality is going to check the background also. That means it is going to check what is the background of student A, what is the background of student B, then only we are going to make differences. So for this student A, we are going to ask out of 10 you need to solve all the 10 questions, but for B we will say that out of 10 you can solve 6 questions. So that 4 questions you should not solve because we understand your background. Then only it will be a fairness to that particular person that belongs to the remote area where good education was not available. Correct? That is substantive equality. We need to check the background also. We need to check what were the living conditions were there, what were the social context was there, what were economic background was there, what is the educational background was there. All these things we need to take into account before actually measuring them, before testing them on the same parameters. That is known as substantive equality. So Supreme Court says that Article 15.1 actually promote this substantive equality, and this Article 15.4 and Article 15.5 basically promote that dream of Article 15.1, and that is the reason is these Article 15.4 and 15.5, they are not exceptions to the article number 15.1. Next is this, that the Article 15.4 and 15.5 basically they employ group identification as a method. Group identification as a method through which substantive equality can be achieved. That means we can create the group. That means like should be treated alike. Like should be treated alike only. Correct? So for example, if there is a class, actually 5 students are there, class 5 ke students hai, correct, and they actually taking this education from the same school, then they can be given the same question paper. But if suppose another class 5 student is there, he actually living in the rural area where that good education is not available, he was taking this education from the primary school where good infrastructure, good teachers, they are not available, then definitely we cannot give the same paper to this guy also, same paper to this student also. We need to create the group. But yes, whosoever student is taking education from this particular rural school, okay, under this class 5, we can give the same question paper to all the students because this group is identical and this group is identical. That's what Article 15.4 and 15.5 says, that group identification as a method through which substantive equality can be achieved. And this may lead to an incongruity where certain individuals members of an identified group that is being given reservation may not be the backward. What said by the Supreme Court here is, Supreme Court says that it may be possible when we actually make such group identifications or when we provide reservation, then it may be possible the some of the persons from that particular reserve category, they may not be the backward, their economic conditions is well-being, their educational conditions is well-being, okay, but still they can get the benefit of the reservation. It may be possible, and it also may be possible that those who are not belong to the reserve category and they are actually backward based on economic backward also, based on educational backward also, but they are not getting the benefit of reservation. It may be possible. So Supreme Court is not denying it. Supreme Court says that it may be possible individual belonging to the non-identified group. Non-identified group means non-reserved group may share certain characteristics of the backwardness with the member of the reserved group. But the thing is this, but it cannot be used as in to negate the role of reservation. But it cannot be used to completely remove this option of reservation. Correct? So this was said by the Supreme Court here is. Now next thing what Supreme Court says, that merit versus quota. So in this merit versus quota, Supreme Court says that an open competitive exam may ensure formal equality. That means a open competitive exam is there. Here we are not going to check what was your background, economic background, educational background or social background, but this exam is available to everyone. That means everyone is going to get this opportunity to write the exam. So if we carry this thing without checking the background, actually we are going to promote the formal equality. That means we are treating everyone equal only without looking the background, where everyone has an equal opportunity to participate. So we are going to promote formal equality but not the substantive equality. But Supreme Court says that there is a widespread inequalities are there in the availability and access to educational facilities, and it results in the deprivation of certain class of people who would be unable to effectively compete in such a system. There are few students will be there, those who are not getting that good educational facilities, that will result in the deprivation of this certain class. So if they are also actually competing in the same competitive exam, definitely they will be at the disadvantaged positions. So that is the reason is special provisions like reservation is provided just to ensure substantive equality. So here Supreme Court says that. Now Supreme Court says that success actually not belongs to only the education. Success belongs to few other factors. Like for example, capital culture. Okay. Cultural capital. So based on cultural capital means what? Suppose example, okay, you are going to appear for the IAS exam, correct? Your parents are also IAS, your mother or father, suppose example, either of one is IAS, your actually uncle, they are also, okay, very good educated, your entire family is good educated, the chances are that you also will going to be good educated because you are getting that environment in your family. You are having that is cultural capital, correct? And compared to that student who is preparing for the IAS but he is living in the rural areas, in the remote areas, neither of his parents or her parents, they are completely educated that much. Family members are all not able to guide that student, and that is the reason that the student is not aware about UPSC, the syllabus, the way we need to read or study, nothing, he is not aware. Definitely that student chances to clear IAS exam in the first attempt will be very rare, correct? So that is cultural capital is there. And another important factor is social network. So even though, for example, if your family members, they are not that much educated, they are not able to guide you, but if you are living in that society where other members are there, community linkages are there, if they are able to guide you, still you can get success. But there are many students are there, they are neither getting this cultural capital, that means their family members are not educated, and they are getting any community link help, that means community members are also not there, surround that student so that they can guide. So that means what Supreme Court says, that there is a combination of family habitus, community linkages, inherited skills, they work to the advantage of individual belonging to certain classes. Now certain classes individuals are there, they are getting these everything, they are available to them, and because of that they are getting success. That means, and then we classified as merit reproducing and reaffirming social hierarchies. Then we say that because they are meritorious, they are very intelligent. No, they are not intelligent or meritorious because they have received that background, they have received that help from their family members, from their community. Because of that, they are able to clear this particular competitive exam easily compared to that student who is living in the remote rural areas and he has studied completely in vernacular language. For them it is a little bit difficult. Then we should not call that the guy, the student who was studying in rural areas, he is not meritorious. So in this case, for example, one case was there, that is BK Pavitra versus Union of India case. Here Supreme Court also had observed that how actually apparently neutral system of examination perpetuates social inequality. That means if we continue without reservation, then this system itself actually going to increase this social inequality further instead of decreasing it. Next thing is, merit actually cannot be reduced to narrow definition of performance in an open competitive examination because it only provides formal equality of opportunity. So merit should not be actually considered as a definition of the performance, correct? So that merit is not alone there, it only provides formal equality of opportunities. So the thing is this, this competitive examination, they do not reflect, this open competitive examination, they do not reflect social, economic and cultural advantage that certain classes they are having, and because of this social, economic and cultural advantage, the certain class of people, they actually get success in such examination. I told you, for example, the person, student A, whose father or mother is IAS or in group A service, his family members may other like uncle or auntie, they are also in the service. Another is B, okay, and he is also getting education, for example, like example Doon school or St. Stephen school. But there is another student B, father and mother both are not educated enough to guide, no help from the community also, he is living in the rural areas, he has studied in the vernacular language. Definitely A is going to clear the exam, but B will not able to clear the B will not be able to clear the exam because of this social, economic and cultural disadvantage. So here we should not say that A is meritorious candidate and B is not a meritorious candidate. A is meritorious because he has received or she has received every advantage in the form of social, in the form of economic, in the form of cultural. So that is the reason is merit, this exam, open exam should not be considered the only criteria, okay, for this merit. Now next thing is, we need to understand that the high scores in an examination, they are not proxy for a merit. What Supreme Court says that whatever the scores you are getting in these examinations, they are not a proxy for a merit. So merit should be socially contextualized and reconceptualized. That means whenever we check person is meritorious or not, we need to contextualize on the social term and reconceptualize in terms of whether someone has received this social advantage, cultural advantage or economic advantage. Next thing is, in such a context only, reservation is not at odds with merit. Reservation is not completely against the merit, but it actually further distributive consequences. It has a consequences that is distributive in nature, and because of reservation only, this substantive equality we are going to promote. So that was the thing said by the Supreme Court. So now at the best, what Supreme Court says that an examination actually can only reflect the current competence of an individual. Whatever the exam is there, this exam only reflect the current competence of an individual, but not the gamut of their potential, capabilities or excellence, which are also shaped by lived experiences, subsequent training and individual character. For example, I am giving you, have you ever read that all those who are receiving AIR 1, okay, in UPSC civil service exam, they are the best officers India is having? No, this is not correct. Even though in that exam they have received rank 1, but this doesn't mean that they are the best officers that India is having. It may be possible that the person or student who has received AIR 100 even, or AIRs for example, okay, 80 or 90, even sometimes for example those who have received rank like example 200, but because of reservation they became IAS now, they are not good. May be possible with rank 200 and with because of reservation that student is getting IAS, they also can be the best IAS officers compared to AIR 1. Correct? So that is the reason the Supreme Court says that an examination can only reflect the current competence of an individual. correct, but not others. And with the help of training, okay, we can improve that candidate. So the meaning of merit actually itself cannot be reduced to marks. So whatever merit doesn't mean marks only, even if it is a convenient way of distributing this educational resources. Supreme Court says that we should not equate merit with the marks. Reservation actually ensures opportunities are distributed in such a way that backward classes are equally able to benefit from such opportunities, which typically evade them because of lot of structural barriers, like for example, not access good education, not access good health, not access good community, not access the good guidance. Because of these structural barriers are there, reservation is the only thing, because of that they got opportunity to enter into the public service. This is the only manner in which merit can be democratizing force. So merit can be the democratizing force with the help of reservation only, and equalizes inherited disadvantage and privileges. Correct? So this was, otherwise what will happen? The claims of individual merit, they are nothing but tools of obscuring inheritances that underlie the achievement. So reservation is not at odds with the merit. That was said by the Supreme Court. So this was today's entire session. I hope you liked the video. Please don't forget to subscribe, to share with your friends. Thank you.